In 2003, Canada's Supreme Court made a landmark decision. In a case called R versus Powley, the court ruled that the Métis, a distinct Indigenous people whose culture developed through generations of kinship between European traders and First Nations communities, primarily across the Canadian prairies, held constitutionally protected hunting rights. It was a genuine, hard-won legal victory, the result of decades of organizing by the Métis Nation itself. In the 2 decades since, something else happened that the Métis Nation did not ask for and does not recognize. More than 30 organizations have formed across Quebec, Ontario, New Brunswick, and Nova Scotia, made up primarily of white French-descendant Canadians, claiming Métis identity and Métis legal rights based on a single ancestor found through genealogy, sometimes born 300 years ago or more. Since 2003, more than 50 of these claims have gone before Canadian courts. Every single one has been rejected. This video explains what actually happened, why courts have consistently ruled the way they have, and what the actual Métis Nation and Indigenous legal scholars have said about a phenomenon researchers now call race shifting. First, understand who the Métis actually are, according to the Supreme Court's own ruling and the Métis Nation's own account of its history. The Métis are one of 3 distinct groups recognized as Indigenous peoples under Canada's Constitution, alongside First Nations and Inuit peoples. Métis identity did not simply mean having some mixed European and Indigenous ancestry somewhere in a family tree. The Powley decision was specific about this. It required demonstrating an actual historic rights-bearing community, one with its own customs, traditions, and collective identity, existing prior to European legal control taking hold in that specific region, primarily around the Great Lakes and the Canadian prairies. The Métis Nation today, representing that historic community and its documented descendants, has been explicit and consistent in its own public statements. There is one historic Métis Nation, with one historic homeland, based primarily in Western Canada. Second, understand what changed after the Powley decision and why. The ruling created a real legal opportunity, hunting and resource rights tied to a recognized Indigenous identity. Historian and researcher Darryl Leroux, who has spent nearly 2 decades studying this phenomenon, found that more than 30 new organizations claiming Métis identity formed in Quebec and the Maritime provinces, specifically in the years following Powley. His research, published in the book Distorted Descent, examined the genealogical claims these groups relied on directly. He found a consistent pattern. Members typically traced their family tree back to a single Indigenous ancestor born between 300 and 375 years ago, then used that one distant ancestor as the entire basis for a personal identity shift, adopted in the present day, often by people who had no prior connection to Indigenous community, culture, or kinship of any kind before making that genealogical discovery. Third, understand exactly why every single one of these court cases has failed, according to the court's own written decisions. The Powley test requires more than a genealogical link to a long-ago ancestor. It requires proving the existence of an actual continuous historic community with its own customs and collective identity, not simply a modern organization built around shared ancestry. In the most prominent case, involving an organization called the Communauté Métisse du Domaine du Roi et de la Seigneurie de Mingan in Quebec's Saguenay region, the court found that the organization itself had been created only in 2005. Specifically in response to ongoing government negotiations over Innu First Nations land and hunting rights in the same territory. The court noted the group's membership process required nothing more than evidence of a genealogical link to a single Métis ancestor and payment of an annual fee. It ruled that a recently formed organization built this way could not credibly claim to be the inheritor of an actual historic community's rights. The case was ultimately dismissed by the Supreme Court of Canada itself in 2019, ending the appeal process entirely. A Quebec judge overseeing a related case put the core problem memorably, stating it would be easier to nail proverbial gelatin to a wall than to find real substance in these claims. Fourth, understand what the actual Métis Nation has said publicly about this phenomenon, because their position has been direct and unambiguous throughout. The Métis National Council intervened formally in several of these court cases, standing alongside affected First Nations to oppose the claims. Following the Supreme Court's 2019 decision not to hear a further appeal, the Council issued a public statement describing these Eastern claims as having no connection to the Métis Nation, and expressing hope that the ruling would deter what the statement specifically called attempts at identity theft. This is not an outside academic characterization. It is the stated position of the Métis Nation's own national representative body, describing how it experiences these claims. Fifth, understand why researchers describe this as more than simply a genealogical misunderstanding. Professor Leroux's research specifically examined the founding purposes of several of these organizations and found that at least 2 were established directly in opposition to ongoing negotiations over Indigenous land and resource rights in their region. one formed specifically in response to Mi'kmaq territorial management, another in response to Innu harvesting rights negotiations. Legal analysis of these cases has made a related point directly. If a legal claim to land or resources cannot be stopped by opposing a First Nations negotiation directly, an alternative some individuals have pursued is finding an Indigenous ancestor within their own family tree and asserting the same category of rights themselves. Indigenous studies scholars, writing about this phenomenon in academic research, describe it using the term self-indigenization, and note it has produced consequences well beyond Quebec, affecting decisions around university admissions, grant funding, and other opportunities specifically intended to support actual Indigenous communities. Sixth, understand the broader legal confusion this phenomenon has exposed, since it is not purely a matter of bad actors exploiting a clear rule. A related 2016 Supreme Court decision, in a case called Daniels, complicated the picture further by ruling that self-identification and genealogy could serve as meaningful factors in certain federal jurisdiction questions, involving individuals with mixed Indigenous ancestry. Legal experts have noted this created a genuine vacuum, one in which universities, government programs, and other institutions have struggled to distinguish good faith claims from opportunistic ones, particularly as the popularity of consumer DNA testing and online genealogy has made discovering a distant Indigenous ancestor easier than ever before for anyone with deep colonial-era North American roots. If this topic affects you personally, here's the distinction worth understanding clearly. Legitimate Métis Nation citizenship is determined by the Métis Nation itself, based on documented connection to the historic Métis homeland and its recognized communities, not by a single ancestor discovered generations later through a family tree. Individuals who discover mixed Indigenous and European ancestry through genuine historical research are not the subject of this specific controversy. The concern researchers and Indigenous nations have raised is specifically about organizations built primarily around asserting legal rights on the basis of ancestry alone, often in direct legal opposition to First Nations and the Métis Nation's own recognized communities. Anyone researching a family connection to Indigenous ancestry in Eastern Canada or New England can consult the Métis National Council's own published position and the publicly available court records from these specific cases for further detail. Subscribe if you want to see more videos that take a careful, factual look at how identity, history, and the law actually intersect, rather than repeating a simplified version of a complicated story. Every week on this channel, we go this deep into the real history behind the stories that shape how people understand their own families and their place in the world. Like this video, hit the notification bell and leave a comment below with your thoughts, respectfully. This is where the real conversations happen on this channel.